Your car's been mangled and you're aching and just wanting to get home, and the next 10 minutes will decide whether you ever see a dime in compensation. Skip one critical step, and Maryland's harsh contributory negligence rule will bar you from any compensation, even when the other driver was clearly at fault. Stick around as I expose the 5 post-crash mistakes that wrecked Maryland injury claims, and the simple moves that keep every dollar on the table. Hi, I'm attorney Bobby Zirkin. I've been a personal injury attorney for over 25 years and a member of the Maryland House of Delegates and the Maryland State Senate, and I've seen the same mistakes happen over and over again. People walk into my office months after an accident, and I have to tell them that their case has been severely damaged by decisions they made in the first few hours and days after their accident. These aren't bad people making bad choices. They're good people who simply didn't know what they didn't know. Today, I want to share the 5 biggest mistakes I see people make after a car accident in Maryland. More importantly, I want to help you avoid them, because once these mistakes are made, they are very difficult, sometimes impossible to undo. The first mistake I see constantly is people leaving the accident scene without getting the documentation they need. I understand the impulse. You're shaken up, you're hurt, and you just want to get home or get to the hospital. But leaving too early can destroy your case before it even has begun. Maryland law requires you to stop at the scene of any accident involving injury, death, or any property damage, even a little fender bender. That's Maryland Transportation Code section 20-102. But the law is just the minimum. What you really need goes far beyond what the statute requires. I had a client last year who was rear-ended at a red light, clear liability case. The other driver was texting and ran right into her, but she was so focused on her neck pain that she didn't take pictures of the scene. She didn't get the other driver's insurance information, just exchanged phone numbers. When we tried to contact the other driver weeks later, the number was disconnected. No insurance information, no photos, no witnesses. What should have been a very straightforward case became a nightmare. Here's what you absolutely must do before leaving the scene. First, call the police, even if it seems minor, even if the other driver is being nice and friendly and suggesting that you all handle it without involving insurance. Maryland requires police reports for accidents involving injury or significant property damage, but I recommend calling them for any accident where fault isn't crystal clear, and really for any accident at all. Second, document everything with your phone. Take photos of all vehicles from multiple angles. Get shots of the license plates, the street signs, the traffic signals, the road conditions, any skids on the road, anything you can find. I've had cases where a photo of a pothole or a broken streetlight made all the difference between winning and losing. Third, get information from everyone involved, not just names and phone numbers. Get driver's license numbers, insurance company names, and policy numbers, vehicle registration information. Again, all the information. If someone claims they don't have insurance, get their employment information today. We can often find coverage through their employer policies or from other sources. Fourth, identify witnesses and get their contact information. Don't just rely on the police to do this for you. They might miss someone, or that person might leave before the officer gets to them or even gets to the scene. Witnesses have a way of disappearing and their memories fade quickly. I've seen cases where the difference between a settlement and a trial, between a good outcome and a disaster outcome, came down to a witness who saw what really happened. Don't let that witness drive away without getting their information. 2. Talking too much to insurance companies. The second big mistake is talking too much to insurance companies, both yours and theirs. I know this sounds counterintuitive. You're supposed to report the accident. That's correct. You're supposed to cooperate. That is also correct. But there's a difference between cooperating and volunteering information that can hurt your case. Your own insurance company has a duty to defend you under your policy, but they're still an insurance company. They're still looking for ways to minimize their exposure, and the other driver's insurance company. They're absolutely not your friend. Their job is to pay as little as possible on your claim. Ideally, nothing at all, as far as they're concerned. I had a case where my client was in a left turn accident. She was making the left on a green light. Not a green arrow, but a green light, when another car ran the red light and hit her. Under Maryland law, she had the right of way. She was already in the intersection when the light had changed. But when the insurance adjuster called, she was nervous. She said, quote, "I was turning left and then the car hit me. She didn't mention that she was already committed to the turn, that she had checked for oncoming traffic, that the other driver ran a red light, that the other driver was speeding. She didn't mention any of those things. And the insurance company used her statement to deny her claim, arguing that she had violated the left turn statute, which was not accurate. Here's what you should do when insurance companies call. First, you must report the accident to your own insurance company. That's correct. Your policy does require that, and failing to report can void your coverage. But when you report it, stick to the basic facts, or better yet, have your lawyer do it with you. Where did the accident happen? When it happened? What vehicles were involved and whether anyone was injured. Don't speculate about fault. Don't guess about speeds or distances. Don't minimize your injuries by saying that you feel fine. Just stick to the basic facts. When the other driver's insurance company calls, you have no obligation to give them a statement. None whatsoever. In fact, you should tell them, here's my lawyer's name, here's my lawyer's number, and that's it. After that, they can't contact you. Despite what they might tell you, Maryland law does not require you to talk to them. You can simply say, again, I've retained counsel, or I'm not comfortable giving you a statement at this time. If you haven't retained counsel yet, you can say, I need time to understand what happened and assess my injuries before I can give you a statement. Better yet, just tell them you have a lawyer and to contact them. If you do choose to give a statement, which you should not, be careful. These conversations are recorded, and every word will be used against you later on. I assure you of that. Insurance adjusters are trained to ask leading questions that can undermine your case. They might ask, you weren't on your cell phone, were you? Even if you say no, you've now put the idea of distracted driving into the record. They might ask about your injuries in a way that minimizes. Are you feeling okay? You're feeling better today? Might seem like a simple question or a polite question, but if you say yes, they'll argue later that you weren't really hurt. The correct answer is something like, I'm still being evaluated by my doctors, or I'm still experiencing pain and discomfort, or again, better yet, call my lawyer. I'm not speaking with you. Number 3, delaying medical treatment. The third mistake is delaying medical treatment. And this one can be devastating to your case. I understand why people do it. They're busy. They think they feel okay. They don't want to overreact. But delaying treatment creates problems that can never be fully fixed in the case. Maryland follows what's called the eggshell plaintiff rule. That means that if you're injured in an accident, the person who caused the accident is responsible for all of your injuries, even if you were more susceptible to injury than the average person. But this rule only helps you if you can prove your injuries were caused by the accident. The insurance company's favorite argument is that your injuries weren't caused by the accident, but they were caused by something else. You might argue you had a pre-existing condition, or that you were injured in a different accident. Maybe you hurt yourself playing sports or doing yard work. They'll argue all of these things. And the longer you wait to seek treatment, the easier it becomes for them to make these arguments. I had a client who was rear-ended on a Monday. She felt sore, but thought it would just go away. By Thursday, she was in really severe pain, but she waited until the weekend to go to the emergency room. The insurance company argued that her injuries couldn't have been from the Monday accident because she waited too long to seek treatment. They suggested she might have injured herself doing something else during the week. We won that case, but it was harder than it should have been. We had to bring in expert witnesses to explain delayed onset of symptoms. We had to get detailed medical records going back years to rule out pre-existing conditions. What should have been a very straightforward case became expensive and complicated. Here's the rule. If you're injured in an accident, seek medical attention immediately. If you're seriously injured, go to the emergency room. If you're not sure how badly you're injured, go to an urgent care center or call your doctor or go to the emergency room. Don't wait to see if you feel better in the morning. Be completely honest with your medical providers about your symptoms and don't downplay your pain or try to be tough. Medical records are some of the most important evidence in your personal injury case. If you tell the doctor you're fine, that's what goes in the record, and that's what the insurance company will use against you, even if you have a serious injury. Also, follow through with all of the recommended treatment. If your doctor refers you to physical therapy, then go to physical therapy. If they recommend follow-up appointments, keep those appointments. Insurance companies love to argue that if you were really injured, you would have followed your doctor's advice. Number 4, accepting quick settlement offers. The fourth mistake is accepting quick settlement offers. I know it's tempting. You're dealing with medical bills. Maybe you're out of work. and the insurance company is offering you a check right now. But quick settlements are almost always, in fact, I would say always, bad settlements. Insurance companies make these quick settlement offers for one reason and one reason alone. They know their exposure is likely to be much higher if you take time to fully understand your injuries and damages, and if you take the time to go get a lawyer. They're hoping you'll take a small amount now rather than wait for a fair amount later. And you must understand, once you settle your case, it is over. If you're injured much more than you thought, and you have massive amount of medical bills later down the road, and you've already settled your case, you cannot come back and try to get more. Once it's settled, it is over. I had a client who was offered $5,000 3 days after her accident. She had gone to the emergency room, but the doctor said she seemed fine. They sent her home with instructions to come back if she was feeling worse later. The insurance adjuster called during that period of time and said that they wanted to take care of it quickly. They would offer her $5,000 to cover her emergency room and a little bit of extra for her trouble, for her pain and suffering, what have you. She almost took it, but something made her call me first, and of course we waited. We waited for several weeks, and soon thereafter she started having severe headaches and memory problems. An MRI showed that she had a traumatic brain injury. Her case eventually settled for 7 figures. That quick settlement offer wasn't generous. It was an attempt to steal. It was an attempt to steal her case out from under her, and again to get a quick settlement that she could never go back. Had she developed these symptoms after settling the case, she would not have been able to get the compensation that she needed and deserved. Here's what you need to understand about damages in Maryland. You're entitled to compensation for your medical expenses, lost wages, pain and suffering, any permanent disability or disfigurement, your future medical bills, and your future injuries. You cannot know the full extent of these damages right after an accident. Medical expenses might include not just your immediate treatment, but your ongoing care, rehabilitation, and your future medical need. Lost wages might include not just the time you've already missed, but the future lost earning capacity or potential if your injuries affect your ability to work in the future. Pain and suffering damages can be substantial, especially if you have permanent injuries. Maryland also allows punitive damages in a limited number of cases where there is intentional misconduct. These damages are meant to punish the wrongdoer and deter similar behavior in the future. But you'll never know if you're entitled to punitive damages if you settle your injury, your accident quickly. Before you even consider a settlement offer, you need to reach what doctors call maximum medical improvement. This means your condition has stabilized. Your doctors have a clear picture of your long-term prognosis. Only then can you and your attorney accurately value your case. And you cannot value that 3, 4, 5 days after your accident. So don't settle these cases quickly and call your lawyer. Number 5, trying to handle everything yourself. The 5th and final mistake, as I've said a couple of times here today, is trying to handle these things yourself. I understand the impulse. You're intelligent, you can read, you can research things online. Why pay an attorney when you can handle it yourself? Here's the reality. Insurance companies have teams of lawyers, adjusters, and investigators working to minimize your claim. They have decades of experience, sophisticated computer systems, and unlimited resources. You have Google and whatever time you can spare from your regular job while you're trying to recover from your injuries. Maryland law is complex, and personal injury law is very complex. We have contributory negligence rules that can bar your recovery entirely if you're found to be even 1% at fault for the accident. We have specific statutes of limitations that can destroy your case if you miss critical deadlines. We have procedural rules that can trip up even experienced attorneys. I've seen people lose cases they should have won because they didn't understand the law. I've seen people accept settlements for a fraction of what their cases were worth because they didn't know how to properly value their damages. And I've seen people miss filing deadlines and lose their right to compensation entirely. I hate to see those folks come into my office. But it's not just about the law, it's about practical experience. I know which insurance companies typically offer fair settlements and which ones force you to file suit. I know which doctors provide the best treatment for accident injuries and which ones write the most helpful reports. I know which expert witnesses are credible and which ones fall apart under cross-examination. Most personal injury attorneys work on a contingency fee basis. This means we don't get paid unless we win your case. We advance all the costs of litigation, and we only get paid if we recover money for you. This aligns our interests with your interests because we want to maximize your recovery because, quite frankly, that's how we get paid and you get paid and we're in this together. I had a client who tried to handle her own case for 6 months. She was educated, really educated, articulate, and thoughtful, and she thought she could manage it. The insurance company kept asking for more documentation, more medical records, more proof of her damage. They questioned every bill, challenged every treatment, and offered her significantly less money each time they spoke. When she finally came to me, I was able to settle her case for 5 times what they had offered her. Not because I'm some magician, but because I understood the process and knew how to present her case effectively. The insurance company that had been jerking her around for months suddenly became reasonable when they knew that she had competent representation. That's not a coincidence. It's because they know and they knew that they could no longer take advantage of her. They also understand that our office takes these cases to court. If you don't reach a settlement, which is a fair settlement for your compensation, we file suit and we go on to court, and we will get compensation for you at some point down the road, but we will not settle for less than what your cases were. Now, I've just walked you through the 5 biggest mistakes people make after a Maryland car accident. These are mistakes that can cost you thousands of dollars, or in some case, tens of thousands of dollars. In some cases, it can cost you your entire case. But knowing what not to do is only half the battle. The other half is knowing what you should do, especially when dealing with insurance companies. That's exactly what I'm going to cover in my next video, questions insurance adjusters don't want you to ask after a car accident in Maryland. I'll give you the specific questions that can protect your case and the ones that can expose when an adjuster is just trying to take advantage of you. These are the questions that level the playing field and put us back in control of your claim. If you've been in an accident, this information could be the difference between getting a fair settlement and getting taken advantage of. The insurance companies are counting on you not knowing these questions, so don't let them win. We'll see you right there.